Senator Paterson.
Thank you, Mr Acting Deputy President. I move to take note of the Government Document Number 2, National Report into Age or Disability-Based Job Discrimination by the Human Rights Commission. The Government welcomes the Australian Human Rights Commission's Willing to Work inquiry report. I would like to thank the Honourable Susan Ryan AO and her team at the Commission for their fantastic work on this important workplace issue. The inquiry was commissioned by this government in April 2015 to investigate employment discrimination against people with disability and older Australians. All Australians deserve fair and equitable treatment in the workplace. Organisations with greater diversity have greater productivity and performance, and their employees are happier. They understand that investing in a diverse workforce is an investment in their future. While I'm on my feet, it would be remiss of me not to acknowledge that this has been a particularly productive use of the Commission's time, and that this stands in stark contrast to some of the Commission's other activities. I'm referring in particular to the Commission's decision to host an inquiry into children in detention, not under the former government, when those numbers were on the increase and reached their peak of 2,000 children in detention, but under this government, when those numbers were decreasing and ultimately reduced to zero. It also stands in contrast to the Human Rights Commission's utter failure in the recent Queensland University of Technology students' case. The handling of that complaint by the Commission has been an utter disgrace. The students in that case have been treated appallingly by the Commission, and the President of the Human Rights Commission, Gillian Triggs, and her delegates have demonstrated that the Human Rights Commission is in dire need of reform as a result of the handling of that case. There are two key issues in the handling of this case. The first is the Commission's extraordinary decision to decide to sit on the complaints from the applicant for a period of 14 months before informing the students who were subject to the complaint. They only decided it was necessary to inform the students 3 days before a compulsory conciliation, which they were ordered to attend. That meant, as a result, that a number of the students were unable to attend and that they were unable to arrange representation.
Senator Paterson, if you just resume your seat. Senator Brown on a point of order.
Order. I may be confused, but I thought we were talking about the Willing to Work report.
Yes, we are, but I note that Senator Paterson has in fact made a significant link to that report that we're actually discussing and contrasting it to other reports, and I think he is in order. Senator Paterson.
Thank you, Mr Acting Deputy President. The first issue is their utter failure to notify these students in the appropriate way, and that resulted in some of those students being unable to attend the conciliation and some of those students being unable to arrange for legal representation at the conciliation. That was an extraordinary failure. The second extraordinary failure of the Commission in this case was to not immediately dismiss it, as it has the power to do under the Human Rights Act, as a vexatious case or a case without merit. This case should never have gone to court. It should never have taken up 3.5 years of the lives of the students in question. And the Commission had the power to alleviate that, and it is extraordinary and disappointing that they did. It was particularly disappointing after the successful resolution of this case, when the federal court comprehensively dismissed the complaint, that Ms Triggs went on the 7:30 report on the ABC, and when asked by the host, Lee Sales, why she did not dismiss this case, she said because she thought it had merit. That's an extremely disappointing thing. And while I'm talking about the QUT case, I think it's relevant to point out some appalling comments that were made on the Q&A program last night by the member for Griffith, Terry Butler. She smeared the students involved in this case by linking them to comments which had been found by the court to be utterly false. One of the students was alleged to have used the N-word in a Facebook post. No evidence was provided to the court that he had done so. He has asserted since the beginning of the case that he did not have a Facebook account at the time, that it was a prank, that someone else had done it in his name. The applicant in this case and their lawyers provided no evidence to contest that, and the judge comprehensively dismissed the complaint against this student because there was no evidence for it. So for a Labor Member of Parliament on a national television program with hundreds of thousands of viewers to imply that this student had in fact made this comment when there is no evidence to find that he did, and the court has comprehensively dismissed it against him, is a disgrace. In my view, Callum Thwaites, Alex Wood, Jackson Powell and also Kieran Findlater, the students in the case who we know the most about from public media reporting, have done an exemplary thing for their fellow Australians. They have stood up to extraordinary bullying, inappropriate use of the law and for free speech. And if they hadn't had the courage to do so, then we would not know how badly this law is functioning, how dire reform is necessary to fix this law. And I think rather than attacking them and smearing their reputations in the national media, all of us should be grateful for what they have done, should be thanking for them what they have done and for their courage. It was not an easy thing to stand up to this. Many students who were accused chose not to, and I understand why they did, but we owe them our grateful thanks.